everyone. Welcome to Crime in Court. This is the Commonwealth versus Karen Reed Trial 2.0, and we are on episode 136, Hank's Terrified of the AARCA Witnesses. And as you can see by the title, we might have some AARCA filings to go through, and there's actually a ton of filings that just dropped. So, let's without any real introduction, let's just get into it because there's a lot. Some of them are, the majority of them are shorter, so hopefully we get through them. Not, it doesn't take too long. So let's get started. Please hit the like button, and let's first talk about the United States Court of Appeals for the First Circuit. So Karen Reed first appealed the double jeopardy claims to the SJC. They denied it. She did a brand new filing with some more information, and they denied that too, but said you can appeal it. They gave him a certificate of appealability, and then with that, they were able to appeal to the First Circuit Court. After this, I guess it's the Supreme Court. So if they choose to, they can appeal this to the Supreme Court. But here is the judgment. There was uh, a whole brief on it, but I didn't order or I didn't print it out. I just wanted to go over their decision. So it says this was entered on March 27th, so yesterday, 2025. This cause came on to be submitted on the briefs and original record on appeal from the United States District Court and for the District of Massachusetts. Upon consideration whereof, it is now here ordered, adjudged, and decreed as follows. The District Court's decision is affirmed. So the District Court denied her appeal. So they're saying her decision, the court's decision in that was they're siding with the court. Karen Reed's motion to stay the state court proceedings pending appeal is denied as moot. So she also had a motion to, that's really tiny. Sorry guys, I could make this bigger. She also had a motion to stay until there was a decision from the First Circuit Court. Well, we have our decision now, so and they denied it. So it is moot, as they say. So that's unfortunate. Very, very, very unfortunate for Karen because it just doesn't seem like the justice system is siding with her and seeing the facts as they are. It's just insane that the prosecution, the judge, everybody else is getting the benefit of the doubt when in fact it should be, a lot of times they should be ruling in the defendant's favor. All right, let's move on. We've got lots to get through. So here's the next motion from the Commonwealth. It's a motion in limine to preclude the reference to redact the manner of death. This is the decision. We have denied. So that is a good thing. The defense will be allowed to bring up the fact that the manner of death is undetermined, and um, but the Commonwealth wanted to redact that. So they don't have that privilege. Basically, so she's ruling in Karen's favor here. So it is denied. The medical examiner will be testifying and can be examined on this issue. Judge Canoni signed it yesterday. So basically stating it's coming in. We're not gonna redact the manner of death on the death certificate, but you have every right to bring it up in examination and talk about it with her there. And that's what you're supposed to do as a lawyer. I think he forgot that. Hank forgets he's supposed to do these things in the proceedings, the trial proceedings, and not like in all these motions. Some of these motions are just so ridiculous and a waste of time. Like this expert, for instance. So, this is the memorandum of decision and order on defendant's motion to exclude certain testimony of the Commonwealth's witness Robert Gilman and in the alternative request for a Daubert Lanigan hearing. So, this was another expert that the defense was trying to strike. He is a meteorologist or something to that effect. So how he's going to be testifying to the firmness or the hardness of the ground, that's that's questionable. And the defense, rightly so, questioned it. Well, here's Judge Canoni's response. There appears to be no dispute that the Commonwealth's proffered expert in meteorology, Robert Gilman, satisfies the foundational requirements set forth in Daubert versus Merrill Dow Pharmaceuticals and Commonwealth versus Lanigan, and therefore may testify as to the weather conditions. So he can testify as to the weather conditions on the night in question. So that's January 29th. 2022. However, the defendant seeks to preclude Gilman from testifying as to the hardness of the ground resulting from the weather conditions to the extent that the Commonwealth seeks to elicit such evidence that the defendant believes is beyond the witness's field of expertise. Defense counsel can object to the line of questioning at trial if the proper foundation for such evidence is not established. Accordingly, the defendant's motion is denied. So she kind of did the same thing here with the defense, saying you have the opportunity to cross examine him. You can object when you don't think that, something should come in. So denied, motion denied. Here is, so this came in yesterday, and there was actually an emergency, or kind of like it was a last minute hearing for Aiden Carney, Turtle Boy, and it has to do with Karen Reed's phone records. So they are in the past there have been leaks to leaks from, I would say, leaks from, I think, people in the Commonwealth, the office there at Norfolk County District Attorney's Office. Somebody is leaking information to the trolls out there, the anti-Free Karen Reed people who love to smear Karen, spread lies, and anyone who posts anything on X. They insult you, call you fat and ugly, tell you you should die, all these horrible things. These trolls are being hand fed information from the Commonwealth, and there are clear examples of this. And some of these people really just basically hate Turtle Boy. And their hate for Turtle Boy is what keeps them, or what prevents them from seeing the actual evidence for what it is. I mean, maybe they do, and they're just a little bit disingenuous. I don't know. But here's a motion from Aiden Carney about getting a protective order in place for this. So, first of all, number one, the question is, we read through Judge Sisitsky's decision, hard to say, his decision in order to turn over certain materials, anything with Aiden and Karen communicating and talking about the witnesses, talking about witness intimidation. Those were the things that they're supposed to turn over. Or yeah, that's what Cosgrove, the special prosecutor in that case, is supposed to turn over. So today there was a hearing about that, and for some reason they had a whole bunch of, well, they had something on a flash drive that they turned into the court. Well, Aiden's claiming I never talked about witness intimidation with Karen, so therefore there's no communications that you should be turning over. Yet here you have a flash drive and you're turning something over. So what is it, first of all? Second of all, is it even within the scope? And third of all, like, I think he wanted him to like check it in camera or something. Well, anyways, the Commonwealth had put not just communications between Aiden and Karen on the phone, but he also did communications between Aiden and Karen's attorneys, which was not in the order from the judge. The judge kind of chastised the Commonwealth, for that. And they have to go back and really look through and parse out what they have on this flash drive and see if there is anything that fits this limited scope for the order. So that being said, so that's how the hearing kind of left off. But that being said, there are these trolls, and anything that were in those, communications that, they say are about witness intimidation or whatever, anything that was in Aiden's phone should be protected and not leaked to these trolls. So that's, I think, what this is about. So let's review. It says Aiden Carney's motion for a protective order regarding the sharing of cell phone data between Carney prosecutor and the Reed prosecutor. Now comes the defendant, Aidan Carney, by and through undersigned counsel, and hereby moves for the protective order pursuant to Mass Art Crim P. Rule 14 to supplement the court's March 21st, 2025 order allowing limited disclosure of Mr. Carney's cell phone data and prohibiting leaks to third parties. The defense herein seeks a protective order to provide him security, clarity, and a mutual understanding of the court's order. An order would ensure the integrity of the transfer and usage of the defendant's sensitive cell phone data between the outside prosecutor appointed in this instant case and the case of Commonwealth versus Karen Reed. As grounds, Mr. Carney states as follows. On March 21st, 2025, this court entered an order granting limited access to Reed case prosecutors to two of the defendant's cell phones accessed by and searched by police in the Carney case. The court ordered ADA Cosgrove, the special assistant district attorney assigned to the Carney case, to provide certain selected data to the Reed case prosecutors from Carney's phone. The court specifically restricted the Reed prosecutors to be provided evidence or data depicting evidence of intimidation of a witness and communications between Mr. Carney and any Reed witnesses or family member of a witness, and that the disclosure must be made by Mr. Carney's prosecutor. In other words, the court's order prohibits the Reed prosecutors from shopping for any information themselves by rummaging through Carney's phone. So you can't just go through my client's phone willy-nilly. Here, the defense is concerned that the history of leaks and exposure of sensitive information and materials to third parties in the Reed case may continue in connection with his cell phone data disclosure. See attached affidavit of Aidan Carney, which we will read in just a second. All right, so in these circumstances, it is entirely appropriate for the court to enter a protective order prohibiting the Carney and the Reed case prosecutors from sharing the information with private individuals, which individuals are uniformly detractors and critics of Carney. So, like I said, they are people who just despise Carney for whatever reason and want to blow his world up. And it's nothing other than that. They don't care if Karen Reed is innocent or guilty. They just despise Mr. Carney for whatever reason. These private parties have in the past publicly claimed to have access to confidential investigative materials. One is presently under a criminal harassment order prohibiting further contact and harassment of Mr. Carney. Based on her statements, it appears Norfolk County law enforcement is sharing private investigative materials related to Carney's case. So it appears that Norfolk County District District Attorney's Office or law enforcement is sharing private investigative materials related to Carney's case. So somebody is leaking. with this particular person who absolutely despises Carney. Someone who has been found by a court to be engaged in a pattern of harassment towards Carney, such that required the issuance of court orders prohibiting such future actions. She's gone to his house, taken pictures of herself at his house, or not of herself, but from his house. There's been, I don't know if she's anything to do with it, but there's been, well, there are many people who don't like him. Let's just say that. I'll say that. All right, so there is reasonable cause to believe police and prosecutors are also sharing such information with other bloggers. Protective orders serve to shield litigants and third parties from unwarranted disclosures and, as a practical matter, to facilitate the discovery necessary for a trial. Pursuant to Mass R. Crim P. 14, Mr. Carney requests that this court grant a protective order restricting discovery of the documents to the Commonwealth attorneys and police and prohibiting dissemination outside of this criminal proceeding at this time, particularly to an individual restrained by a Massachusetts court from harassing and contacting Mr. Carney and other antagonistic private bloggers. Mr. Carney notes with extreme irony that such leaks and publications regarding Commonwealth witnesses are considered felonious witness intimidation as charged and applied against Mr. Carney, likely by the very same persons leaking the instant information with impunity. So basically stating, so Mr. Carney is being charged with witness intimidation, but the irony is that the people who are posting these things or talking, trying to leak these things about Mr. Carney, that is felony witness intimidation. That actually is intimidation, where what he's done has never been intimidation. Um, so very, and they're doing it without any kind of, they're doing it with impunity. No punishment, nothing. They have, free reign to do whatever they want. Such an order will have no effect on the proper execution of the Commonwealth's investigative duty, and it seems impossible for the Commonwealth to conjure a good faith objection to such an order as is proposed herein. All right, so we have an affidavit of Aidan Carney. Now comes the defendant, Aidan Carney, on oath and hereby states the following to the best of his knowledge, information, and belief. I am the defendant in the above captioned matter. I have a criminal harassment order against Catherine Peter. That's the she I was referring to, but there are multiple people, but she's the one that he has a harassment order against. Which was recently renewed for one more year in I think it's pronounced Leominster. That's how you guys pronounce it there, the Leominster District Court. She has also been charged with felonious witness intimidation against me, also in Leominster Court. Peter is also the subject of a criminal investigation order protecting a good friend of mine who Peter targeted solely as a result of her being associated with me. Peter is also associated of violating that order 3 times, and there are criminal cases still pending in the Stoughton and Dedham district courts against her, as well as a felony witness intimidation charge against her in the Dedham district court. The girl's got a lot of problems, but I think because of her connection to the DA's office, she's not getting in too much trouble. All these times she's had harassment orders and she's violated them, and they've never put her away. They've never, revoked her bail or anything like that, which they should have. Technically, if they're following the law and she's committing other crimes, you got to arrest her, but they didn't. So all of these cases have special prosecutors keeping the Norfolk DA's offices, keeping the DA's office away from the cases. I'm trying to protect my friend's privacy and prevent further harassment of her, but if further information is necessary, I will provide it through my attorneys. Peter, according to her Facebook and or X postings, is privy to ongoing information leaks from the Norfolk DA's office in my and the Karen Reed cases. For example, Peter has on several occasions published law enforcement information that has not yet been made public. On October 11th, 2024, the day after I was arrested, Peter, on her Masshole Mafia Facebook page, wrote to Reed Attorney Yannetti, "We know you've been involved in Aidan Carney's little witness harassment game, and your text with him from his seized phones the day before by state police have already been making the rounds." So their phones had just been seized. This was back last year right before she went to trial, or as we were heading into her first trial. And he was in prison. They took his phones, they took her phones, and tried to indict her on witness intimidation and colluding, trying to indict them both on colluding to intimidate witnesses, which the grand jury refused to do. So they came back a no true bill. But so that day after the phones were seized, Kate Peter sends the text, "We know you've been involved in Ian Carney's little witness harassment game, and your texts with him have already been making the rounds." She sent that to David Yannetti. So that is intimidation of a defendant. I don't know if they have rights. They could be a witness, so technically she could be a witness in her own case. I don't know, but they're not gonna do anything about it, I'm sure. Continuing on, it says she also knew, as shown by her post on September 29th, 2024, that I would be arrested on October 10th, saying, "October 10th, he knows the deal." I was, in fact, arrested by state police assigned to the Norfolk DA's office just one day after that assertion on October 11th. So she also knew the identities of Janelle Webb and Michelle Littlefield, the police dispatcher and Stoughton Court employee charged and fired, respectively, in connection with allegations against me before their identities were made public. She could have only acquired this information from the state police or the DA's office. So, proof that somebody is leaking information. There are other bloggers receiving confidential law enforcement information against me as well. One, Kevin Linehan, posts as Yellow Cottage Tales and reports over and over that his information comes from multiple sources connected to MSP, the DA, and witnesses, and that he gets information from multiple close sources that the MSP and the Norfolk DA have been informed that, etc., etc. So, uh, they have an exhibit of his posts. And finally, one Jennifer Coffindaffer has been used as a third-party mouthpiece revealing confidential information for the DA's office. She was privy to GPS data relating to Ms. Reed's vehicle in that case, which she published 2 weeks prior to law enforcement revealing it to the public, and also knew that the DA's office would seek mitochondrial DNA testing in that case 6 weeks before that before it was publicly revealed. So Jennifer Cobbendaffer's leaking stuff too about the case specifics about what the investigators are doing. Based on the above, it is clear that the DA's office and or the state police assigned to the office are leaking confidential data and will continue to do so with my phone data. Oh damn. This is great. So, I mean, putting it out there in a filing, I think, and on the record is awesome because we all know this stuff is going on. So this is awesome that they were able to do this. And the judge was, I believe he said he was going to take it under advisement with this, but I'm pretty sure he's probably going to rule in favor of Aiden. He seems really level-headed. Thank goodness this isn't Canoni that's ruling over this because all of Aiden's phone would be blasted all over the internet by now. All right, so the next motion is the Commonwealth's pretrial memorandum. Here's the proposed statement of facts to the jury. On the morning of January 29th, 2022, at approximately 6:04 a.m., the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road within their town. Officers respond, why is it outside a residence? How about on the lawn of 34 Fairview Road? Like, they're trying to distance it even further by not saying it was the lawn of this home. They're just saying outside. He was just found outside at a residence. Officers responded and discovered the male party subsequently identified as John O'Keefe off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours of that date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to the Good Samaritan Medical Center, where he was subsequently pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene, while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies that she has committed any crimes. So that's their proposed facts to the jury. I don't know. I believe that's read prior to or with jury instructions, perhaps. I'm not really sure. Here are some proposed stipulations that the Commonwealth wants the defense to stipulate to, I guess. I don't know. So, the Commonwealth proposes the following stipulations to be entered as evidence at trial. Number 1, in lieu of testimony by the keepers of records for different institutions where the Commonwealth obtained surveillance videos, the defendant agrees to the authenticity of each video. So we don't have to keep calling people up to verify, or authenticate. Did you pull this video from the hard drive? What did you do with it after that? Those kinds of testimony. So in lieu of testimony by the keepers of record for C.F. McCarthy's and Waterfall Bar and Grill, the defendant agrees to the authenticity of the restaurant receipts. So they don't have to call anybody from the restaurants, well, unless they wanted to, but they don't have to call anybody from the restaurants to authenticate any of the receipts. In lieu of testimony by the keepers of records, and in lieu of testimony from any defense counsels, the defendant agrees to the authenticity of her audio and video recorded statements made during interviews with reporter Gretchen Voss, she's from Boston Magazine, reporter Matt Gutman with ABC News, reporter Dennis Murphy, and he's with NBC, and reporter Ted Daniels, Boston 25. This stipulation also includes any recorded statement made by the defendant to ABC, including ABC News 2020, where she did Karen Reed, The Perfect Storm, Good Morning America, NBC Universal, including Dateline, which was called The Night of the Nor'easter, and any statements of the defendant to Terry Muir from Unsolved Productions, or appearing in A Body in the Snow, the trial of Karen Reed, appearing on Investigation Discovery HBO. So all her statements, she is going to stipulate that she agrees those are her statements. Those are accurate and true. Whatever, or interviews or notes or whatever gets handed over in those things. So they don't have to call every single one of those people. In lieu of testimony by the keeper of records, the defendant agrees to the authenticity of statements attributed to her in a 2-part Vanity Fair article entitled Karen Reed Tells Her Story, a Homicide Trial in Massachusetts by Julie Miller, published on October 29th and October 30th of last year. In lieu of testimony by the keeper of records, the defendant agrees to the authenticity of William Reed, Janet Reed, and Nathan Reed's recorded statements, audio and visual, to Ted Daniels and Boston 25. The parties agree that the known DNA standard for John O'Keefe may be admitted without testimony from the forensic scientist, Ms. Sophie Horizon. I don't know if I'm saying that right, that created the standard. The parties also agree that the standard may be used and referenced by analysts from the Massachusetts State Police Crime Laboratory, Bodie, and U.S. Davis Veterinary Genetics Lab when they testify to their work, analysis, and conclusions based on samples of this matter, including making statistical opinions based on the standard for John O'Keefe. Okay, that was a lot of words. Basically, the parties agree that the standard can be brought up, the standard that was used. The parties agree that the DNA standard may be admitted. So they're talking about the DNA standard that they use for the scientific testing and whatnot. In lieu of testimony by the keeper of records, the defendant agrees to the authenticity of her medical treatment records and the medical treatment records for John O'Keefe and the admissibility of such records subject to appropriate redactions. In lieu of testimony by the keeper of records, the defendant agrees to the authenticity of reports generated by the Canton Fire Department. In lieu of testimony from Andy Klain and Mike Miroli, the defendant stipulates that on September 23, 2024, Aperture LLC inspected, photographed, measured, and laser scanned the defendant's 2021 Lexus LX 570, John O'Keefe's 2019 Chevy Traverse, and the outside of 34 Fairview Road. So this was done at the end of last year after the first trial. On October 2nd, the driveway and surrounding area of 1 Meadows Ave were photographed and laser scanned. So they did John's house, or I'm sorry, 34 Fairview Road, where John was found. They did uh, John's house, which is 1 Meadows Ave, and then they did Karen's car and John's car. Additionally, the Commonwealth's, well, we don't know who these are. These must be, oh, yes, they're from Aperture, which is the company that they've used for like basically all of their experts. So this is like the best paid experts they can get, the Commonwealth. So this company called Aperture, we've got other experts from Aperture that Karen Reed has tried to exclude. Additionally, the Commonwealth proposes when questioning witnesses for uniformity and efficiency, the parties agree to use the transcripts from the prior trial that do not contain the sidebar conversations. And that is signed by Morrissey and team. Next up is the Commonwealth's motion to compel reciprocal discovery of AARCA witnesses or to exclude their testimony. So this is like a, hey, Judge, you've already ruled twice now that the AARCA witnesses can come in after objections from the Commonwealth, but here we're going to ask you to reconsider that again. But it doesn't even say a reconsideration. It's just the same talking points. So the Commonwealth is seeking a viable remedy for the defendant's repeated Rule 14 violations and varying representations about the relationship between the defense and the AARCA witnesses. The Commonwealth does not believe that the defense has complied with the Rule 14 nor the court-ordered discovery. We're going to get there because the defense has a response to this. So just I'll refrain from saying too much right now because they're going to tear this up. And these was, I don't know when these were filed, but they were both filed at the same time, or at least added to the docket at the same time. So I'm not sure, they must have kind of overlapped when they filed. So I don't know if they've seen, if the defense saw this and then did their response, or if the defense was already working on their response before this finally came out. I'm not sure which came first. So the Commonwealth does not believe the defense has complied with all the discovery rules. The Commonwealth cannot wait until the middle of the trial to properly prepare for the cross examination of the defense experts. Why? Why do you have to do it now? Because you want to get a second bite at that apple. You want to take your first bite and then have at it at trial for your second bite. And that's the only reason why I could see him saying that this is not sufficient. They're ready to go to trial August 1st, right? And why at the very last minute, 4 days from jury impanelment beginning, why are we now saying, well, we can't go to trial without this information? It's just too important. Like, what were you doing without it before? How did you be, how were you able to do the trial the first time without it? I mean, it's really not that critical. In addition, the defense's suggestion that it may request AARCA to conduct further review and/or testing would be in violation of the March 6, 2025 reciprocal discovery deadline, Rule 14, and the court-ordered directives. Therefore, the Commonwealth requests that this court order the defense to comply and certify its discovery obligations to exclude the AARCA witnesses. If the court is going to allow the AARCA witnesses to testify, the Commonwealth requests a hearing within 1 week to inquire of the witnesses about their past relationship and interaction with the defense to identify any materials the AARCA witnesses have received that are not listed in their report and when they received materials and the basis for any opinions outside the four listed in their February 2024 report. I just want to say Hank has everything he needs. He doesn't need to keep hashing at this, but he's hashtag Hank. And so, yeah, he will. He, there, I'm sure he sees them as his biggest threat because they are put together, well spoken. They don't budge on their opinions. And they're going to say that Karen Reed's car did not hit John. And that's bad for his case. So this is now the third time or something that they were asking for AARCA to be struck. And I think it's so ridiculous. And yet we can have meteorologists and dog trainers come and testify to things that are outside the scope of their expertise. It's insane. In support of this motion, the Commonwealth states the following. In advance of the retrial, the Commonwealth began requesting discovery related to the AARCA witnesses on December 5th, 2024. The court allowed the Commonwealth's motion and ordered the discovery. Based on the defendant's repeated failures to produce discovery, the Commonwealth moved to exclude the AARCA witnesses on February 11th, 2024. The court recently denied the Commonwealth's request to exclude the AARCA witnesses. So the court recently denied the Commonwealth's request to exclude them. So why are you asking again? At this time, 5 days prior to the start of trial, the Commonwealth has yet to receive the required and appropriate discovery and rather received notice on March 25th that the defense is contemplating the possibility of engaging the AARCA witnesses to provide additional opinions and conduct further testing and analysis. The defense's position that material ordered in Exhibit A and are not within the custody and control, and therefore they cannot provide, is inadequate. The defense must comply with the court's order for the defense to call the AARCA experts as witnesses. Additionally, on March 20th of this year, it was disclosed to the Commonwealth for the first time, listen to this, and in open court that Attorney Yannetti had received a federal subpoena from the United States, from the United States Attorney's Office to produce his entire case file. On March 25th, 2025, the defense further disclosed for the first time that the subpoena that Attorney Yannetti was referring to was an ongoing federal subpoena. On March 25th, 2025, the Commonwealth was informed that discovery produced to the defense was then being turned over to the attorney's office. So the Commonwealth is handing over discovery to the defense. Then the defense has is handing that over to the U.S. Attorney's Office. He has a subpoena. He has to. He's required. So I don't know what the big deal is, and what's Hank getting at? That like David's crooked or something because he's turning over Discovery? I don't think so. When he's supposed to, and under a federal subpoena. So on March, I read that. Sorry. Did I finish the sentence? It's an ongoing matter. The Commonwealth was informed that discovery produced to the defense was in turn being provided to the USAO in an ongoing manner and included the entirety of the Commonwealth's discovery referenced in notices of discovery run 1 through 57. They've had many discovery notices. Notice 57 was provided to the defense on January 30th, so they're even beyond that. Commonwealth still seeks the following discovery: all bills, invoices, contracts, retainers, engagement letters, or repayment or payments that have been created for the defense of Karen Reed or provided to or from the Reed defense team from March 1st, 2024 to present. All emails, letters, and or any written correspondence, including text messages at any time between any employee of ARCA and any member of the Karen Reed defense team, including Karen Reed herself. All phone ledgers evidencing phone calls or text messages between any employee of ARCA and any member of the Reed defense team, including Karen Reed at any time. All written communications or a summary of oral communications between any employee of ARCA and any member of the Reed defense team, including Karen Reed, relative to any facts, claims, documents produced, or any other information about this incident that is not listed in the February 2024 report. A written summary of all testing and findings that were conducted by ARCA employees Scott Klein, accident reconstructionist, and Jeremy Robbins, mechanical engineer. The source of all information about DNA and forensic evidence that was provided to Dr. Wolf and Dr. Rentschler prior to their testimonies. All data, photographs, videos, and any testing, regardless of whether testing is the basis for any opinions. This request includes all data and memorialization of any failed tests. A copy of the federal subpoena received by the defense team referred to by Attorney Yannetti, so he wants a copy of the subpoena. An exact copy of all materials that the defendant provided to the USAO, including a list of the content of all materials provided to the USAO, two, the date that each was submitted to the USAO. An exact copy of all materials that the defendant provided directly to any of the ARCA witnesses at any time. The defense's TUI request to the USAO following the USAO's March 4th, 2025 letter and any subsequent responses. If all the requested discovery is not provided to the Commonwealth or the defense, certification that each request has already been provided, the Commonwealth requests that the court exclude the ARCA witnesses. So Hank's not messing around. He really wants those ARCA witnesses gone. Here's his affidavit in support of that. He is Hank Brennan, appointed special prosecutor and assigned as lead counsel for the case. I began my appointment in mid-September 2024. The Commonwealth sought and obtained a court order for discovery pertaining to ARCA witnesses on December 5th, 2025. The Commonwealth has repeatedly informed the defense and the court that it believes the Rule 14 and court-ordered discovery has not been satisfied. On March 20th, 2025, Attorney Yannetti disclosed to the court that for that he had received a subpoena to the court, that he received a subpoena from the USAO's office to produce his entire case file. The Commonwealth was unaware of this information. So this happened in March 20th of this year. But when did the subpoena happen? I don't know. He disclosed it on the 20th. Were they at a hearing? I don't remember this. But um, there's so many like explosive things that happen in a day or in filing or in a hearing. So it's like you miss some of these things. I don't remember Attorney Yannetti saying this, but it says he disclosed to the court. Maybe it was in a sidebar, perhaps, but um, it's out there now because Hank put it out there. So the Commonwealth was unaware of this information. Additionally, the Commonwealth has no idea what Attorney Yannetti provided to the United States Attorney's Office, nor does the Commonwealth know what was provided to the AARCA experts other than what is listed in the group AARCA report. After court on March 25th, 2025, the defense disclosed that the subpoena Attorney Yannetti was referring to was an ongoing federal subpoena. Commonwealth now understands that the defense has been providing all discovery to the USAO in an ongoing manner, all material outlined in the Commonwealth's notices of discovery 1 through 57. It's like he's telling on them, like, Mom, they're telling on me, so I'm telling on them. Like that's kind of what this feels like to me. Like, come on, Mom, he's telling on me. He got me in trouble. Like, really? Is this what we're doing now in court filings? David Yannetti had a subpoena to hand over everything. That doesn't mean diddly squat. And I don't, I mean, he's supposed to. I don't know what Judge Cannoni's supposed to do about it. On March 25th, 2025, the Commonwealth learned that the defense may ask AARCA to engage in further review, analysis, and testing, which could result in further discovery. Discovery deadlines have passed. The Commonwealth will not be able to fairly prepare its expert witnesses for new materials, testing, or opinions. The Commonwealth will not be able to prepare for new opinions beyond the previously provided report. The Commonwealth cannot adequately prepare for trial without all court-ordered and Rule 14 discovery. Hank Brennan. Hanky Brennan on the loose, trying to wreak havoc on Massachusetts justice system. So, what do you think the defense is going to say about this? They're probably not happy that they keep getting asked for discovery that they don't have. And this discovery that all of a sudden he's listing out, it's like, buddy, you do have this. And they testified in trial one. Just go back and read their testimony. That's all you got to do. And then you know what they're going to testify to. So you don't need a Daubert. You don't need anything. Shut up and sit down. That's what I have to say. So here comes the notice of reciprocal discovery regarding AARCA witnesses. This is from the defendant. Hereby submits the following notice of reciprocal discovery regarding AARCA witnesses, Dr. Wolf and Dr. Rentschler. Request number 1. A complete statement of all opinions to be expressed by Dr. Wolf and Andrew. Hold on. I apologize. I'm sorry for that. I have no idea what that was. And she was sound asleep under a blanket and decided to just bark. So I hate when she does that. Let me read that again. Request number 1. A complete statement of all opinions to be expressed by Dr. Wolf and Andrew Rentschler, Daniel Wolf and Andrew Rentschler, and the basis and reasons for each opinion. This information in the possession, custody, and control of the defense has already been produced and can be found in the AARCA report, voir dire testimony, and trial testimony of Dr. Wolf and Dr. Rentschler. Go back, watch their voir dire, watch their testimony. You can watch it. You don't even have to read it. And yeah, you have the information you need. Request number 2. All notes, reports, and materials relied upon either witness for what? That's a mistake. When um somebody made an error and she's probably whoever writes this is quoting somebody else's document. So it says all notes, reports, and materials relied upon either witness for reviewing this specific case. Request for materials is not limited to the expert's report. The Commonwealth is requesting all materials relied upon in review, even if the materials are not part of the expert's report or opinion at trial. All materials reviewed by Dr. Wolf and Dr. Rentschler were listed in AARCA's report. The United States Attorney's Office formally authorized the defense to independently retain AARCA and produce additional discovery to the experts for their review on March 26, 2025. That same day, the defense provided additional materials to AARCA, including Welcher's reports for potential rebuttal testimony. All materials were immediately produced to the Commonwealth in reciprocal discovery. So they met their requirements. They are going to use the Commonwealth's experts' report against them, using the ARCA witnesses. So I think that's excellent. And that's got to get them shaking in their boots because they don't want the ARCA experts reviewing their experts' opinions. Request number 3. A copy of all materials provided to ARCA, Dr. Wolf, Andrew Rentschler, or any representative of the United States Attorney's Office by any member of the defense team or by the United States Attorney's Office. The request includes all materials, including written, documentary, video, witness statements, and witnesses produced. All materials provided to ARCA by the defense have been produced in reciprocal discovery. A copy of the grand jury subpoena issued by the United States Attorney's Office to Attorney David Yannetti, dated November 22, 2022, demanding production of all materials produced in discovery to date by the Commonwealth in Commonwealth versus Karen Reed, as well as all relevant investigative material, was produced to the Commonwealth in reciprocal discovery. Pursuant to that subpoena, the defense produced the discovery included in Notice of Discovery 1 through 47 to the United States Attorney's Office. On October 22, 2024, the defense provided the United States Attorney's Office with discovery relating to the vehicle reconstruction for the Department of Justice's determination regarding whether to provide this information in turn to the ARCA experts. So basically, um, the defense provided discovery to the USAOs and to the USAO, and they didn't hand anything over directly to ARCA. It seems it's that they gave discovery directly to the DOJ to determine whether they were going to provide it to the ARCA witnesses. It was not up to the defense, is what they're saying, that was provided. We turned everything over, but we don't, it wasn't up to us. We left it up to the DOJ to decide. The defense's understanding is that this information was not provided to ARCA, Dr. Wolf, and/or Rentschler by the United States Attorney's Office. A copy of the specific information produced to the United States Attorney's Office on October 22, 2024, relating to the reconstruction was produced to the Commonwealth in reciprocal discovery. So they have it. They have the discovery. So stop saying you don't have it. Based on our best efforts and reasonable, or what was the word he used? He made up a word. Hank did, and I can't remember what it was. It has something it was like a variation of reasonable. Based on the best efforts and reasonable review of the files, all additional information relevant to this request that was produced to the United States Attorney's Office by the defense was produced to the Commonwealth in the federal materials both sides received from federal government pursuant to the mutual TUI requests in February of 2024. The defense's understanding is that the only discovery materials produced to ARCA by the United States Attorney's Office were the materials listed in their report. Let me say that again for the people in the back. Defense's understanding is that the only discovery materials produced to ARCA by the USAO's office were the materials listed in AARCA's report. So even if there was a subpoena where David Yannetti is supposed to be turning everything over to the AGO, it's it's irrelevant because it was never turned over to AARCA, if that makes any sense. Request number 4, all materials provided to either witness after the conclusion of the defendant's first trial. All materials provided to Dr. Wolf and Dr. Rentschler after the conclusion of the defendant's trial have been produced. Request number 5, describe and produce any exhibits to be used as a summary or support of the opinion. All exhibits, excluding any exhibits necessary for rebuttal of Welcher's testimony, have already been produced. Number 6, are you seeing a theme here? That there's things are already produced or have already been in the possession or control of the Commonwealth this whole time because they've been turned over or they've had access to the transcripts? Request number 6, describe all compensation paid to either expert for all work done regarding this case, including case preparation, testimony, travel, and expenses. The only funds paid to AARCA to date is the $27,606.41 detailed on the invoice previously produced to the Commonwealth in reciprocal discovery. On March 26, 2025, the defense retained AARCA for the second trial. A copy of that retainer agreement and rate sheet was produced to the Commonwealth. So, again, you have it all in your discovery. It's all been turned over. Request number 7, provide any contracts, agreements, or documents relative to Daniel Wolf, Andrew Rentschler, and AARCA discussing compensation relative to this case. All information responsive to this request has been produced. Again, you got it. Request number 9, which actually should be 8, says provide all written communications, including emails and text messages between any member of the defense team and employees of AARCA. All information responsive to this request has been produced. Again. Request number 10, provide copies of all testing not previously disclosed, including crash tests, video reenactments, and any other testing materials and results regardless of whether the witness will testify to the information at trial. So remember, there were other people from AARCA who the defense didn't call. There's one other witness from AARCA that they didn't call. All information in the possession, custody, and control of the defense has been produced. To the extent additional testing is conducted in furtherance of rebutting the testing conducted by AARCA, that information will be produced forthwith. So basically, as soon as we can get it. Request 11, provide all written communications, including emails and text messages between the United States Attorney's Office and employees of AARCA. All information in the possession, custody, and control of the defense has been produced. Request number 12. Provide all communications between the United States Attorney's Office and any member of the defense team as it pertains to the expert's testimony in this case, including dates and substance of phone calls, copies of any written correspondence, dates of any strategy meetings, and list of materials received by the United States Attorney's Office. All communications responsive to this request have been produced. The TUI materials received by the defense from the United States Attorney's Office in February 2024 are identical to the TUI materials produced to the Commonwealth. So you have it. You have the same thing we got. Request number 13, provide a copy of all written requests that have been made by the defense team pursuant to whatever statute that is, the TUI statute, relative to either expert or AARCA. Did I miss pages on this? Hold on. All right, the last line got cut off. All it says is all TUI requests relating to Dr. Wolf, Dr. Rentschler, and or AARCA have been produced. I guess you could have guessed that. So, that is their response to that. They're saying, "We've already given you everything, so shut your yap, Mr. Brennan. We are sick and tired of hearing you whine about this ARCA discovery. You have everything, so shut it." So we'll see what happens there. If I were to guess, I would think that the defense filed this first, and then the um, prosecution filed their response to it, the motions for discovery for ARCA. Because now they're saying, well, we just found out that this was going on, that there was, so I don't know. It almost seems like we read it backwards, but I'm not exactly sure. So we'll see what happens there. I don't see Bev excluding them, and maybe their response, the defendant's response, might actually help them, not have to do the 2A request because they have everything. They're proving like, hey, everything that you asked for, it's been turned over. So shut it. But who knows in Bev's court? All right, so now we're getting into the defendant's motions. We've got the defendant's motion for discovery request. This is a weird one. So hold on to your seats if you haven't already. Defendant Karen Reed files the instant motion for specific discovery pursuant to Mass R. Crim P. Rule 14 on the eve of trial as a housekeeping matter to ensure discovery is complete in advance of trial. Defendant requests the Commonwealth produce the following materials. These are weird, guys. I mean, get your brain thinking. Any contracts, agreements, records of payment, or documents relative to or discussing compensation of any experts in connection with this case. Any recently discovered or previously undisclosed prior bad acts evidence of any witnesses that the Commonwealth intends to introduce at trial. Who's got some bad acts that the Commonwealth might have as a witness? Any information, including any oral or written statement or communication of any witness suggesting a reluctance or refusal to testify in connection with this case. So, were there people that said, I don't want to testify? I want to know that too. Who had a reluctance or a refusal to testify? I could think of one person. If you guys remember, we talked about him. I've talked about him on my channel. The Turtle Boys talked about him. His name is Steve Scanlon. And he was one of the individuals he was the individual who reportedly, allegedly, went to David Yanetti's office on like February 3rd or 4th, like right after she was arraigned, and basically said, your client didn't do this. Brian Albert, Brian Higgins, and Colin Albert did. And since then, and if you watch the Body in the Snow episodes, the docu-series on Max or Discovery Plus, they go into that a lot. David Yannetti talks about that, how that changed the trajectory of how they investigated this case going forward because they knew they had to prove her innocence. And I mean, like, prove it. Like, not just, get a possibly not guilty or whatever. You need to prove somebody else did this. So any information, including any oral or written statement. Well, anyways, what I was going to say before I get into the next statement is that Steve Scanlon reportedly didn't want anything to do with anything. Then afterwards, he was like, "Oh, hold on. I don't want to be a witness. I don't want to. I don't want to, testify." So he kind of backed out, and he didn't help any further. But he did give that tip. So if there's someone like that that the Commonwealth had as a witness, perhaps Steve Scanlon, who refused to testify. I don't know if it was him, but they need to disclose that. Any information, including any oral or written statement or communication of any witness wherein a witness suggested a reluctance or refusal to cooperate. I wonder if any of the McAlberts didn't want to cooperate at first. perhaps. I don't know. Do the defense know something that is behind each and every one of these statements? I wonder. Any information, including any oral or written statement or communication of any witness, including any promises, inducements, or rewards made to any witness in this case. Are you promising someone that, maybe Hank will get a judgeship out of all of this? Are you promising any of the witnesses? Well, Hank's not a witness, but that should be disclosed. They wouldn't disclose that, but they should if that was going on. Things like, maybe somebody's uh maybe somebody's got some criminal charges pending, like a Ryan Nagel or somebody, I don't know. And they say, well, we're going to have all that go away if you testify that you say you saw John like at the back of her car, or you saw him hit her, or whatever. So those are kinds of things that may or may not have been going on. I don't know what happened, but to put all of these things in a filing, it's very strange, very odd to me. Any information, including any oral or written statement or communication of any witness for what can reasonably be defined as a quid pro quo in connection with this case. So you scratch my back, I scratch your back. We both get something good out of this deal. Any information, including any oral or written statement or communication of any witness indicating an intention to or the possibility of changing any part of his or her testimony at trial. Like, hey, maybe Katie McLaughlin, you could say, she said I hit him. You could say that. You could say you heard him say that or heard her say that. And, or maybe she suggested, hey, didn't she say I hit him, I hit him, I hit him? Like I could just say that she said that. So maybe they knew that they were putting on a witness that I'm not saying, I'm not suggesting or alleging any of these. These are all made up in my head in the spur of the moment. I don't know what's going on. So I'm not, alleging that Katie McLaughlin was coached, even though I think she was. But I'm not saying that, those conversations actually did take place. Just so nobody on the troll side think so. All right, so a copy of all communications regarding any meetings between any witness with any member of the Norfolk County District Attorney's Office, including but not limited to Norfolk County District Attorney Michael Morrissey himself, Special Prosecutor Hank Brennan, ADA Laura McLaughlin, ADA Adam Lally, and or ADA Caleb Schillinger. He is working the federal appeal, and or any member of the Massachusetts. So communications regarding any meetings between any witnesses with any of these individuals. So if Michael Morrissey is texting Brian Tully or emailing Brian Tully and saying um, stuff about the case, about the witnesses, like make sure that we get Aiden, whatever. Those are the kinds of things that should be disclosed. As grounds, therefore, the defendant states that the requests made herein are reasonable, necessary, and made in good faith. So that made in good faith, to me, tells me there's a reason for each and every one of these. There's something that the defense team knows that may cause them to be wary of all of these things. And so they are made in good faith. They have a reason, some kind of evidentiary reason to believe that some of these things may or may not be occurring. So, and they're consistent with the objectives of Rule 14. Conclusion, wherefore Ms. Reed respectfully requests that this honorable court allow the defendant's motion for specific discovery. So we'll see what happens there. Here's an affidavit in support of that motion. Elizabeth Little says she does hereby depose and state the following is true to the best of her belief. I am a partner at the firm Worksman, Jackson and Quinn. I represent defendant Karen Reed pro hoc vice. I submit this affidavit on personal knowledge in support of defendant's motion to compel specific discovery. So the motion that we just read. I believe that the requests herein are reasonable, necessary, and made in good faith and are consistent with the objectives of Rule 14. I believe it is in the interests of justice for the court to allow this motion. So that's interesting. There's some nefarious things going on in Canton. All right. Next up is the defendant's motion to impound in support is an exhibit. They want to impound Exhibit 1 in support of the defendant's response to the redacted presentation of the Commonwealth's witness, Dr. Judson Welcher, which we will read their response in just a second, but this is their motion to redact. So now comes the defendant, Karen Reed, and respectfully moves this honorable court for an order impounding Exhibit 1 in support of defendant's response to redacted presentation of Commonwealth's witness to Dr. Judson Welcher, MS, PH. I think he's a PhD. Good can see good cause exists for impoundment of this motion because, among other considerations, it contains photographs of the decedent which are subject to a protective order. And here is the response, the defendant's response to the redacted presentation of the Commonwealth's witness, Dr. Judson Welcher. I think, is this our last one? Yeah, this is our last motion. This one's a little bit longer, so I saved it for last, but it just kind of fit in that order anyways. So now comes the defendant, Karen Reed, and respectfully submits to this honorable court its further response in support of the arguments set forth in the defendant's motion to exclude the testimony of Commonwealth's witness, Dr. Judson Welcher, and the request for voir dire and defendant's correction with supplement to defendant's motion to exclude the testimony of Judson Welcher and request for voir dire. That was really long. We've got some notes here. So it says the defendant hereby incorporates defendant's motion in limine number 11 and exhibits therein and correction to defendant's motion in limine number 11 and the exhibits therein. General reference of defendant's motion in limine number 11 include the defendant's motion in limine number 11 as well as the defendant's correction with supplement to defendant's motion to exclude the testimony of Commonwealth's witness, Dr. Judson Welcher, and request for voir dire. Specific references to either the defendant's motion to eliminate 11 or correction of the defendant's motion to eliminate 11 will be noted accordingly. Oh, good. We're going to have to discuss that as we go through. All that means is there was one that was filed and then there was a correction to that. So there's two documents and they're going to be talking about both here. So now comes the, nope, I read that already. Da, 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 da. In that motion and through defense counsel at oral argument on March 20th, 2025, the defendant identified numerous defects in the proffered testimony of proposed Commonwealth expert witness, Dr. Welcher. Given the magnitude and obvious nature of these defects, including the lack of cognizy and even clarity relating to his methodology, his repeated straying beyond the permissible scope of his expertise, and his intrusion into the province of the jury by attempting to evaluate and credit fact witnesses, the Commonwealth agreed to advise and redact Dr. Welcher's materials. So let's just backtrack a little bit. So his methodology sucks. He strays from his own like scope of expertise, meaning like he talks about things that are out of his wheelhouse. And sorry, my lips are chapped. And finally, he takes oh that's yeah, he decides for himself what is fact. So he will look at, the witnesses' statements and things, and he credits what statements are going to be, accurate or trustworthy. So he can just be like, well, I believe all of the Commonwealth's witnesses and I don't believe any of the defenses. You know, he could be extremely biased. So that's not allowed. Like that, you can't, you're an expert. You're not supposed to be looking at the statements of witnesses in any other way than to gather knowledge and not to form an opinion. All right, so this altercation was to include a significant reduction in the size of the presentation, which was originally 140 slides, and to remove the many defects. So there were a lot of defects with the slides, and there were too many, and there were a lot of problems with some of the things that he had on them. On the evening of March 24th, 2025, the Commonwealth produced to the defense a supposedly revised presentation titled Welcher Trial PowerPoint Final Notes, Box Path Redacted. Um, okay, so unfortunately for the defendant and the court, the only real difference between the original presentation and the redacted presentation is the redaction of the images. So the only real difference is the redaction of the images of John O'Keefe from the hospital and autopsy. The redacted presentation is still the exact same size and length, 140 slides, and none of the defendant's concerns with its contents, which the Commonwealth acknowledged and agreed with and committed to the court that it would be resolved by removal, have yet to be addressed. As the Commonwealth has failed, yet again, to sufficiently show that Dr. Welcher's methodology is commonly accepted in the relevant scientific community, or that it satisfies the apt Daubert-Lanigan factors, and failed to properly narrow the scope of his testimony, the entirety of Dr. Welcher's proposed testimony must be excluded. So he couldn't narrow it down. He couldn't follow the court's instructions. And here we are. It should be excluded altogether. Neither the defendant nor the court should bear the consequences of this recalcitrance and the apparent attempt of the Commonwealth to yet again use the proximity of the start of trial to cause decision making that reflects such proximity rather than the merits of the arguments of the defense. In other words, it is the Commonwealth, not the defendant or the court, that should bear the consequences of the Commonwealth's recalcitrance here. So they should pay the consequence. They should take accountability. In all of the defendant's papers related to Dr. Welcher's proposed testimony and at oral argument on March 20th, 2025, the defendant has raised the two following primary issues which are fatal to Dr. Welcher's ability to testify as an expert. One, beyond Dr. Welcher's total lack of clear explication of his own methodology across the entirety of his proffered materials, neither Dr. Welcher nor the Commonwealth at any point discuss how Dr. Welcher's methodology is commonly accepted in the relevant scientific technical community, or alternatively, how it meets the apt Daubert-Lanigan factors as is required for his certification as an admissible expert. So he hasn't addressed his lack of, using a standard methodology. And he also doesn't address the fact that he how does he, you haven't explained how he meets the Daubert-Lanigan factors as is required. And two, Dr. Welcher's proposed testimony veers far outside the scope of his qualifications and expertise, for example, only drawing medical conclusions untethered to forced calculations and crediting the testimony to other select witnesses. So he's saying, like, well, Trooper Paul said that he did a sideswipe and he did a pirouette and he spun 30 feet or flew 30 feet in the air and backwards and whatever. So I think Trooper Paul is accurate and credible. So I'm gonna just say in my report that that's what happened. But you can't do that as an expert. You can't take other witnesses' statements as fact. But that's what he's doing. In all of the materials which the Commonwealth has produced, including the original presentation, the redacted presentation, and Dr. Welcher's letter, the methodology used for any of the several tests and wayward experiment of Dr. Welcher conducted in preparation for testifying is not stated with any scientific method or any clarity at all, let alone legally supported by a Daubert-Lanigan discussion. Where are we at? Okay, the experiments conducted by Dr. Welcher, which were apparently prepared solely for the instant litigation, including the blue paint experiment and the drop test experiment, are not accompanied by a mandatory discussion of their acceptance in the appropriate scientific community or replicability in any of the Commonwealth's material. So, how did you do these tests? Like, where did they come up? Where did you come up with these tests? Where's the evidence to show that these tests are reliable and scientifically, accurate and, that we should trust these? They have yet to do that. Further, Dr. Welcher, who is not a medical doctor, forensic pathologist, or a medical examiner, attempts to opine on the medical cause of manner of John O'Keefe's death when he proffers that the totality of the evidence is consistent with the right rear corner of the Reed 2021 Lexus impacting John O'Keefe and Mr. O'Keefe, striking the rear aspect of his head on the frozen ground. I don't know how you can come up with that conclusion, but okay. On several occasions, through Dr. Welcher's letter and presentations, he impermissibly credits the testimony of other select witnesses, including Julie Nagel, Richard D'Antano, Ryan Nagel, Heather Maxson, Jennifer McCabe, and Ian Whiffen. So all Commonwealth witnesses, if you didn't notice. No witness, neither a lay witness nor an expert, may offer an opinion regarding the credibility of other witnesses. So, even if you're an expert witness, that doesn't mean you can offer an opinion on their credibility or, by stating their testimony as fact in your report, that's basically giving your opinion on credibility. So, yeah, you can't do that. Such testimony impermissibly intrudes on the jury's province to assess the credibility of the witnesses. Such testimony, the kind where an expert witness assesses the credibility of another witness, could substantially influence the jury's decision about whom to believe. Vouching for the credibility of a witness, whether explicitly or implicitly, is impermissible. So even if explicit or implicit, so even if it is kind of like I'm implying that I believe them because I put their quote in my report. So that's also not allowable. Allowing the glaring problems with Dr. Welcher's proposed testimony, the Commonwealth stated at oral argument on March 20th, 2025, that any reference to witness testimony needs to be redacted, opinions on credibility needs to be redacted, but there are different demonstrations that we do expect as far as extraneous commentary. No, that's not intent. What? Who is talking here? I'm confused. According to the glaring problems with Dr. Welcher's proposed testimony, the Commonwealth stated at oral argument. Oh, okay, so Hank said this. Any reference to witness testimony needs to be redacted. Opinions on credibility needs to be redacted, but there are different demonstrations that we do expect as far as extraneous commentary. No, that's not intended. It's not proper, and we wouldn't try to use it. So Hank said that in a hearing on March 20th. In reference to the length of Dr. Welcher's original presentation, the court asked if the Commonwealth intends to use all 140 pages or however many slides. And the Commonwealth responds, no, that is, we were comprehensive in the production to the defense so they could see the data points, how it is produced. And so we've included, you see, many of the slides in the cameras showing the different downloads. There's only a fraction of that we would show. So, addressing Dr. Welcher's crediting of other witnesses' testimony, the Commonwealth stated that Dr. Welcher will not talk about opinions or testimony of witnesses, including Jennifer McCabe, Ju- Julie McCabe, Julie Albert, you mean? Julie Albert, Julie Nagel, and the Ford occupants, or the people inside 34 Fairview Road. That's Heather Maxon, Ricky Dentano. They had a Ford F-150, I think. All right, so unfortunately for both the defendant and the court, and contrary to the representations of counsel for the Commonwealth in court, Dr. Welcher's redacted representation does not remedy the concerns raised at the March 25th hearing. Slides 103 through 121 still contain an unchanged depiction of the blue paint experiment without any discussion of Dr. Welcher's methodology. In fact, there is no discussion of Dr. Welcher's methodology at all in the entire redacted presentation, and certainly no reference to a potential methodology's acceptance to the relevant scientific community or how it meets the apt Daubert-Lanigan factors. In Dr. Welcher's redacted presentation, he retains his impermissible conclusions as to the cause and manner of Mr. O'Keefe's death, which clearly lie outside the scope of his expertise. This section includes Dr. Welcher's determination that the Reed Lexus hit John O'Keefe by considering images of evidence found at 34 Fairview Road, cell phone data, medical images and notes, and images of Mr. O'Keefe from the hospital. Dr. Welcher concludes that the defendant hit John O'Keefe because of physical evidence at scene, lacerations to O'Keefe's right arm, skull fracture location, and absence of other fractures, and that O'Keefe's skull fracture pattern and location is consistent with the ground contact and not an assault. Really? Could you get any more obvious that you are trying to cover up that Brian Albert, Brian Higgins, and Colin Albert, and Chloe Albert all beat up John that night? Could we be any more obvious? He puts it in his report that he was not assaulted, but his injuries were from hitting the ground. On slide 136, Dr. Welcher uses medical terminology to determine that the totality of the evidence is consistent with the right rear corner of the Reed 2021 Lexus impacting John O'Keefe and Mr. O'Keefe striking the rear posterior aspect of his head on the frozen ground. As Dr. Welcher is not a medical examiner, forensic pathologist, nor a cell phone forensic expert, these conclusions are beyond the scope of his expertise. So he shouldn't be opining on any of that. Incredibly, despite express statements to the contrary, the redacted presentation maintains the impermissible grounds upon which Dr. Welcher bases his conclusions, including the crediting of the witness testimony. Despite changing the language on the slide, Dr. Welcher still concludes that there's no physical evidence to indicate the taillight was broken as of approximately 5:08 a.m. on January 29, 2022. The conclusion is not based in fact, and although the Commonwealth must have communicated the necessity of changing it, as evidenced by the altered text on the slide, the baseless conclusion remains in the redacted presentation. Okay. So they're saying there was no physical evidence to indicate the taillight was broken as of 5:08 a.m. But shouldn't it have been broken by then? Or are they saying that that there's nothing to prove that she broke it by hitting John's car. Anywho, they changed the text on the slide to say something other than what it said the first time. So that's interesting. And it was that the Commonwealth coaching the expert to change their testimony or change their slide to say whatever's going to help their case. On numerous occasions in the redacted presentation, as he did in the original presentation, Dr. Welcher inappropriately usurps the power of the jury by making factual determinations as to the credibility of other witnesses involved in the case. On slide 33, Dr. Welcher credits the expert testimony of Commonwealth expert Ian Whiffen as fact. Per report from Ian Whiffen, O'Keefe's cell phone data showed most notably all device lock events, including the final lock event at 12:32 a.m. So he locked his phone for the last time at 12:32 a.m. If, according to Nicholas Guarino, Karen Reed got back to John's house at 12:36 a.m., that would be a 4-minute drive. It's actually a 6-minute drive, so how would she would really have been flying on those icy, snowy roads after drinking. So I seriously doubt it. So she was long gone by 12:32. According to this, per report from Ian Whiffen, O'Keefe's cell phone showed most notably all devices lock events, including the final lock event at 12:32 a.m., were user initiated by the user pressing the side button briefly. So he shut the phone off, just turning it the side button. I believe he had an iPhone. On slide 37, Dr. Welcher credits the testimony of Julie Nagel and the other members of the F-150 and for not having seen Mr. O'Keefe when they arrived at 34 Fairview Road. By all accounts, Julie Nagel, Richard Dentano, Ryan Nagel, Heather Maxson, they were all in the F-150 except Julie Nagel was on foot. And they had gone back inside for Julie Nagel, 34 Fairview Road, in under 5 minutes from their arrival. They did not see damage to the Lexus because it had not happened yet, according to his report. Did not see O'Keefe ever because he was still in or near the Lexus when they drove off 2 minutes before, which is not true because they all testified that Karen was alone in the car. Or at least Ricky testified that Karen was alone in the car when they drove off. Despite explicit confirmation by the Commonwealth that such impermissible reliance would be removed, the statements remained in the redacted presentation. As all parties well know by now, the touchstone of admissibility is reliability. Commonwealth versus Sands. The Commonwealth has had their independent opportunities to establish any reliability for Dr. Welcher's testimony, but has failed to do so each time. Dr. Welcher's original report and letter retain the foundational problems with the content and scope of Dr. Welcher's proposed testimony discussed above. At oral argument on March 20th, the Commonwealth acknowledged and conceded the several and serial deficiencies with Dr. Welcher's proffered testimony and agreed to remedy them. In Dr. Welcher's redacted presentation, no such remedies were made. So they agreed to make these changes and they didn't. In fact, the most significant change made to Dr. Welcher's original presentation was redacting nearly all images of Mr. O'Keefe from the hospital and autopsy. Although this likely should have been the standard procedure from the beginning, the Commonwealth has employed the substantively inconsequential update as a red herring to distract from the still present deficiencies of the redacted presentation. The defense does not recall raising a problem of redacting photos of Mr. O'Keefe. So this has never been an issue before, so why do we have to do it now? Even something as simple as reducing the size of the presentation below the gargantuan and unworkable 140 slides to something resembling a fraction of what the Commonwealth would show, Dr. Welcher and the Commonwealth failed to make good on. So they didn't do any real changes other than redacting the images of John's autopsy photos. And that's that. They didn't reduce it. They said they would. They didn't narrow it. Nothing. Although once is more than enough, the Commonwealth's repeated failure to satisfy the necessary common law requirements for demonstrating the reliability of expert testimony mandates the exclusion of Dr. Welcher's testimony in its entirety. As a final note, during the March 25, 2025 hearing, when discussing Dr. Welcher's redacted presentation, the Commonwealth stated the following: I can be clear, there is no new information. The statement that Dr. Welcher redacted from his presentation contains no new information is inaccurate. So let's take a look at this. It says, transcript from the March 25, 2025 hearing has not yet been produced. This quotation is derived from the following source, and they got it off of a YouTube video, and they provided the timestamp there. All right, so the statement contains no new information. That's inaccurate. Slide 36 of Dr. Welcher's redacted presentation replaces a video of an aerial view of 34 Fairview with snow on the ground to a cartoonish mock-up of what appears to be a parking lot. What? While the meaning of this change is unclear, Slide 102 materially changes the language of the conclusion as compared to the original presentation. All right, what happened here? Compare original, the right rear taillight of the Reed Lexus was not broken when Karen Reed backed out of John's residence. How is he able to determine that? That's not his decision to make. At approximately 5:07 a.m. according to the infotainment system. No physical evidence to indicate the light was broken at this time. The right rear taillight of the Reed Lexus the Lexus LX was not broken by contact between Karen Reed's Lexus and John O'Keefe's Chevrolet when Karen backed out of John O'Keefe's residence at approximately 5:07. So they did change that. No physical evidence to indicate the taillight was broken at this time. Hmm. 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 Interesting. Where did we leave off? Slide 123 is entirely different from its original presentation counterpart. Slide 123 changed from a labeled diagram of a yard of 34 Fairview with snow on the ground, apparently from the January-February of 2022, to a Google Maps image of a yard of 34 Fairview when there was no snow, apparently from a different time of the year. Once again, the meaning of such a change is unclear as it is non-responsive to the concerns addressed by the defendant and stipulated to by the Commonwealth. So they originally were like, here's our final version, you guys take it. And then they were like, oh, wait a minute, we've got concerns about this, this, and that because of the witnesses and because of this and whatever. And then they come back with a few changes that have nothing to do with anything that they had concerns about. So, yeah. As a result of these changes and the recalcitrance of the Commonwealth to follow up on its own commitments to the court and to the defense, the defendant requests the exclusion of Dr. Welcher or, at a minimum, a voir dire hearing of him. Conclusion: the Commonwealth has repeatedly failed to show that Dr. Welcher's methodology is sufficiently reliable via common acceptance in the relevant scientific technical community or by meeting the apt Daubert-Lanigan factors upon its original production of materials. Dr. Welcher has strayed far beyond his area of expertise in formulating conclusions related to the instant matter. The Commonwealth appears to have conceded this as fact and agreed to remedy the inappropriate proposed testimony. The Commonwealth has, by their own standards set forth on March 20th, failed to do so. The Commonwealth made both substantively meaningless changes by redacting the original presentation and also notable and impactful changes to the substance of Dr. Welcher's presentation well past applicable deadlines despite claiming the opposite and without explaining their reasons. So they're making these changes without any reason to explain why on their final presentation, and it's not the changes that they asked for. It's very odd that they're still finalizing their final presentation. The Commonwealth made substantively meaningless changes by redacting the original presentation. The redacted presentation does not address the defendant's concerns nor the Commonwealth's own stipulations in any meaningful way. The proverbial waters are now more insufficient for the Commonwealth than ever before. Given that that's a good sentence. Given that Dr. Welcher and the Commonwealth have not addressed any of the serious defects attendant to Dr. Welcher while simultaneously changing the substance of Dr. Welcher's proposed testimony in a belated any illegal attempt to bolster the testimony. Is it supposed to say wait? I don't know. The defendant and the court are actually in an even further posture of prejudice regarding the contents of Dr. Welcher's testimony than they did before the redacted presentation. So they're in a worse spot than they were because they didn't make the changes and now they're doing some shady stuff. The court cannot countenance the Commonwealth's approach in this regard. Dr. Welcher is merely another in a long line of Commonwealth experts where the Commonwealth does not come anywhere close to satisfying the apt law and hopes to have their expert witnesses' testimony admitted while keeping its contents vague. The important difference here is that the Commonwealth acknowledged their own deficiencies in open court only to ignore them in this moment. The Commonwealth must bear the consequence of its own actions here, not the defendant or the court. For all the reasons stated herein, the testimony of Dr. Welcher should be excluded. And then that's signed by her attorneys. That was a good one. I liked that one because I thought there were some good lines in there and some good arguments. Will it fly in the face of Kanoni? I don't know because Kanoni is corrupt and Kanoni will do what Kanoni wants and nobody can say otherwise until the feds come. So there's that. Or until she retires. Let's retire early. Get off the bench, Bev. You're too old. You're too grumpy. Just go home. You don't want to be there anyways. You can go retire at your cape. Goodbye. Stop harassing this poor innocent woman. That's what I say to Bev. What would you guys say to Bev if you had the opportunity to say something to her? Let me know in the comments below because I'm very interested what you would say. If you just happen to run into her in a public setting, what would you say to Judge Bev? Let me know in the comments below. Don't forget to hit the like button, and I will see you guys in the next one. Take care. Bye now.